Let's get
This is
all our
excuse
wisdom
me.
out early. We'll make our jokes
This is
later.
a
Okay, we're
Jewish,
done.
this is an Orthodox Jewish event that's called for one. That means we start at 2.
Do we want to wait a little more, or do we want to start?
I think they started lunch at the same time as our panel.
We give it a couple minutes.
Okay. We can start? Okay. All right, guys. Well, thanks for everyone for joining. My name is Keith Larson. I'm a reporter with The Real Deal, not to be confused with the Real Deal event, but we're a magazine. And today we're going to be discussing foreclosures, bankruptcy, restructurings. Everyone here is an expert and deals with that in different capacities. And so I have David Goldwasser, who's with FIA Capital, Michael Davis with Plymouth, Greg Corbin, Northgate, and David Scharf, Morrison, Cohen. And so today, the first question that I have is that you're all kind of seeing distress play out a little bit differently. But where are we in this distress cycle? I mean, at the beginning of the pandemic, we were hearing about all this distress that was coming, but it seems like it hasn't, fully happened yet. So maybe, Michael, I'll open up to you. Where are we right now?
Yesterday we had an eclipse, and I couldn't help but think about something that a very wise person shared with me years ago, that if the sun were to blow up, no one on Earth would know it for about 8.5 minutes. And you'd be walking around thinking everything is fine, but you're already dead and you don't know it. And I think part of the challenge of how distress manifests is the day you realize you have stress in your life, and the day that that problem is going to crystallize, actualize, and come to a head, there's a pretty long lead time. And in every deal, and everyone up here will have lots of funny stories about it, the moment that you realize you're in trouble, the gestation period can be really, really long, and the trigger will be different every time. Sometimes it'll be an investor stress, a partnership dispute, a foreclosure, a bank event, a regulatory taking. Something will be the thing that pushes you off the edge. But usually there's a recognition, and everyone who's ever been distressed knows this, that you knew that problem existed, and then you tried to figure out if you might be able to buy enough time. So all those terms like extend and pretend,
Right.
pick a sort of a broad hyperbole and it'll work, is that gap period of, oh my God, we're in trouble, until the precipitating event brings that to fruition and crystallizes it. You're going to be able to pretend if you have a property that has some amount of cash flow. But there will always come a day when you have to pay the piper. It'll be a maturity or something else that causes that event to trigger. But from what that means on where we are in the cycle, I think we're still in very early innings. There's a lot of challenge that has to work its way through a cycle, and we've built machinery like a gear train that slows that down enormously. It's not a single axle spoke, right? There's a lot of gears, and so you can delay things for a long time. And the question is, how honest are you being with yourself about where you are and what the options on the table for you are to either admit that you're in real trouble, or maybe there's a way to work it through?
Right. David Scharf, do you have any opinions on this?
Yeah, talk to me about which asset class are you asking me about, and what region are we talking about?
Right.
Right. Pandemic had an effect on office. Before that, we were watching retail struggle. We're seeing that rebound. Everyone was crying in New York because of the changes in the laws relating to rent stabilization in 2019, but it only started to come home to roost as maturities came around with higher interest rates in the last couple of years. So it's very asset class specific. It's also regional changes on a state-by-state basis. I think anytime you're looking at an interest rate move of the nature that we've seen, it affects all asset classes, especially since people were frankly getting high on floating rate loans and didn't think they needed to get rate locks. So where we are in the cycle is, I think there's a tremendous amount of money actually sitting on the sidelines, opportunistic money, that's going to cause the market in the near future to really have an opportunity to reset, for bases to start coming down as people recognize they're in distress. That is that moment of recognition. When is the bailout going to come? It's not like there isn't money sitting on the sidelines waiting for all of that to happen. So I think we are getting towards the end of the cycle. I'm not sure if it started in 19, 18, or 2022.
Got it. And then I guess that follows into my next question, which I want to get to Greg and David, because you guys are seeing this on the ground. A borrower comes to you and they say, I'm in distress. I got this loan that's either coming due or is due. I can't pay it. What do they do? What do you tell them, David?
Again, sort of like David just said, each case is very specific.
Right.
Like what Mikey just said, each deal parameter has a different tactic. So if they really don't have cash flow, then you have to sit down and talk to the lender, or there is, nothing going to happen except for lawsuits. If there's issues with the lender sweeping the cash and they're not able to pay, if it's because of the rates, if it's because of execution of the plan. Guys in the last panel spoke about the execution. If you can't execute your business plan, then you're fooling yourself, right? So a lot of guys bought out of town, or I call it out of New York. I live out of town. They bought out of town. They bought these, with money, with reserves to turn over units, raise rents. And then in the middle, or right in the beginning, interest rates and insurance hit them. And then all of a sudden, they don't do any of their unit turns. They don't have any rent coming in, or any of the new rents coming in. They vacate the units. So now you have a year and a half of nothing going on. They paid debt service out of interest reserve. And as he said, the day of reckoning comes. What do I do now? So they just wasted a year and a half of not talking to their lender, not trying to figure out how to do it. And as somebody else said, many of these people are syndicators. They don't have any money. They bought the deal for a fee, and they keep on telling their investors, I have a plan, but they don't really have a plan. Because every plan to get out of any situation has to have some type of execution. The execution might be giving back the keys. It might be making a deal with a lender, might be selling the property. Greg and I work together many, many times where we work with the lender to say, you're never getting all your money back.
Right.
But in some cases, it is nobody's fault, the market, the this, the that. And, let's maximize the proceeds. In New York City, the transfer tax is one of the biggest costs of a sale. That could be a monumental difference in the number of recovery, which is, a lot of the bankruptcies are going on now. But, the biggest thing is to be able to actually look yourself in the mirror, see what the problem is, and then address it with the lender, because otherwise they are just going to sue. And personal lawsuits are coming out daily now, which were not part of the last go around. Everything is about the PGs, whether they're manufacturing the defaults or whether they're calling them. Almost every caption in every lawsuit, and I'm sure David could tell you, does not only list the borrower entity, it lists the guarantor, whether or not it was full recourse or not. And that's the biggest change, where people are having this aha moment of, like he said, I got real problems. It's not just I have a property problem, I have a personal problem.
Right. To explain that to people here, people are personally liable then for the
Right.
debts, not just the company entity.
It was in general the practice that they would only go after the company, and then at some point later, there would be potentially some recourse if there was a deficiency, if you trip something up. Now, just about every lender and servicer is making assertions that you trip something up from day one or some point in the time. So when they start their foreclosure lawsuit, they are naming the individuals in the foreclosure lawsuit, not just for purposes of deficiency, but claiming that they are full recourse in order to induce them to do something. And I mean, I have 4 or 5 major clients or people that I've uncovered. They didn't realize judgments were against their names, because they said, okay, I'm just going to let the property go, non-recourse, no problem. And the attorneys didn't catch, for whatever reason, it wasn't you. The attorneys didn't catch that the lawsuit was against a person. So now you have somebody who owns many hundreds of millions of dollars of properties with a $40 million judgment in their name. Of course, there are offsets when you sell the property, but who wants to go up and go to refinancing and all of a sudden say you can't close because I have a $40 million judgment in your name? What happened? And the guy says, I have no clue. And this is happening daily.
I think the issue really is the depth of the distress that we're seeing here is causing the lenders or whoever is buying the note to look at other sources of repayment. And it's, as soon as you start talking about non-institutional note owners, they know where the deep pockets are, and it's the guarantor. Because the depth of the stress is deep enough that there isn't going to be a recovery from the property, which is why when you get into these negotiations, the first thing that the lenders are asking you for is a pay down, a pay down, a pay down. Because things are so out of whack, things are so out of balance, they're either going to take it from you in the negotiation, or they're going to try to get it from you on the back end in the litigation side.
They create, if there is a guarantee on the loan, even non-recourse guarantee, because almost every loan has some type of a guarantee. They have been calling those as full recourse for one of the 75 reasons that are in the small fine print. And again, it's defensible, and again, David could speak to, the legitimacy of each of these, but they are naming the guarantors. Correct.
I think then we'll get to Greg in a moment, but it's worthwhile we're on this topic, talking about
Sorry, Greg.
the basket of remedies that are available to people is a smorgasbord, and counsel is going to, depending on whether you're on the side of the borrower or the lender's got their own pressures to think of. And so historically in New York, you had to pick your remedy, which is you're going after the property or the guarantor first. And because of the duration of a judicial foreclosure proceeding in New York, the obvious answer is always chase the property because that's where the value lives. But if you're the lender and it's pretty clear that value is underwater, the variable starts to become the behavior of the borrower, right? So are they going to fight this tooth and nail to the end, and then only find out later, because this always comes to the very end of the transaction, that forgiveness of indebtedness income is the world's most evil form of a phantom gain, right? Not all of you know what that is. A phantom gain is when you owe a tax liability with no offsetting cash distribution. So if you owe a bank $1 million and the property liquidates for $500,000, even if they went in the right order, they went for the property first, you're going to get a 1099 for $500,000. It's ordinary income you owe Uncle Sam. And so at the end of it, the guy's like, I'll give you the keys. He's then going to run into the buzzsaw because he wasn't necessarily the most sophisticated tax counterparty, and they hadn't lived through this particular reality in the cycle, that they're obligated to ordinary income for money they didn't get. And if they were a syndicator, it's even worse. It was never their money in the first place. And so it's really important, and I don't sit in this role, the other three guys on the stage all do, is to understand as early as possible what you're up against and to get very good advice early in this process. Because you might think, okay, I'm willing to give the keys back, I've told my investors, and then you're going to run into this problem later if you've got a personal judgment against you. And by the way, it's from the IRS.
And I guess that leads me to the next question. Greg, when is bankruptcy the option? When should a borrower put the entity into bankruptcy? When is that appropriate?
I wanted to talk about which inning we're in. I want to elaborate on that. I think last year I'd heard someone on a panel say that we weren't even inning one. It was stretching on the sideline or in the batter's box, which I think was actually pretty accurate. This year we're starting to see things just beginning to dislodge. It was pretty, I think the stat is over $200 billion worth of maturities that were from 2023 were kicked out into 2024. And that pushes it to about 900 billion. But that's a big chunk, 200 billion that they didn't, it means it didn't sell and they didn't do a workout. They just gave forbearances to put the 200 into 2024. As far as, again, where we are, I think it's indicative. It's a good barometer that, in the past, David would come to me towards the end of the process. And it was at the stage of liquidation where they'd say, we're time to bring in a broker, time to sell the property. We've already done all the legwork and, the law portion of it and the restructuring and everything led to the point of time to sell. Now a lot of it is the opposite. A lot of borrowers are showing up on our doorstep and saying, I need to stop paying because I only have one more month of, money or reserves. Do I approach the lender? Can you approach the lender on my behalf? Do I just stop paying? Will they get their ear more? Will it be more leverage, or is that a bad idea? So now we're seeing it. We're kind of like, at the door, and it's almost a turnaround where we're then, referring out or recommending, and we say, you need a great lawyer like David or a great CRO like David in that situation to almost kick off the process. So whereas we were always kind of like the last guy in, we're now the gatekeeper of a lot of people, and we have that information that we know that certain banks don't even know yet that their borrower is going to stop paying. So this is like the very, very beginning of that. But I think this year is going to be, towards the end of the year, a lot more telling.
Got it. I mean, that kind of Another question, I mean, David talked about, what you do at first, a borrower comes to you, they're in distress, maybe they have a personal guarantee, what do you do there? How do they get out of that situation? How can they get financing to exit the situation? How can they refi? What are their options right now, given that a lot of banks have pulled back and financing is extremely expensive right now? David, what are their options?
So I think there are lots of things on the menu that we started to talk about. I want to pull back to the bankruptcy aspect for a minute, because what David was talking about and Greg is talking about is really important to know that taxes, whether it's COD or whether it's transfer taxes, can be mitigated in a bankruptcy situation. The other component of it is in any loan, you've got recourse if the borrower causes or files a bankruptcy. So it goes to the heart of, are you working with your lender? How does your lender look at the problem-solving notion of what you're trying to accomplish? In a bankruptcy, you can slide a C Corp in to try to mitigate some of the COD income. You can save on the transfer taxes if you can run a 363 sale pursuant to a plan. All of this requires time and planning. When the person walks in and says, I've got 1 month left on cash flow, and then I'm out and I'm screwed, you're screwed at that point. If you weren't aware 12 months earlier that you're running out of cash and that you have a problem and you weren't engaging with your lender is going to look at you potentially as one of those bad actors who thought that they can work their way out of things, borrowing from here. The short answer is you've got to come up with a plan that's executable, that's realistic. And part of that is recognizing that there are actually opportunities for finance out there, whether they're bridge lenders, whether they're high interest lenders, and you're going to have to give up something in exchange.
What are
Your
you
equity,
giving up?
if your equity is underwater, start working to get back into your equity. You've got to face the reality. You've got to go to your investors and say, we're underwater, this deal is dead. Instead of giving back the keys, this is what I'm going to do. I'm going to work for free. I'm going to give up my management fee. I'm going to go get a new lender to come in, and we're going to try to work our way out. People don't like hearing it being called a hope note. It doesn't need to be a hope note, but it's working your way out of a situation where you had a thinly capitalized deal, and the risk and execution on a thinly capitalized deal is, if anything in your business plan doesn't go according to plan, you're out of the money. And that means you've got to give up your original hope of what your business plan was going to produce for you. So go back to your hope note, which you had at the beginning of your plan in your pro forma, and try to work your way to being able to earn it. But there's money out there. Yes, is it costly money? The answer is yes. And nobody wants to pay for it, but the equity's out. So let's recapitalize. Let's look at the opportunity that's ahead of you. Let's reset the marketplace and start working towards solutions. It's the hanging on. It's the kicking the can down the road all the time without a plan. Bad for the banks, and bad for the borrower.
But is that going to stop anytime soon? I mean, what is the incentive for this extend and pretend to end?
The
Or do-
PGs. I mean, I think that's what we're seeing, right? The lenders, and there's a lot of trading going on, and I know for my borrower clients that come to me, pardon me, the oh shit moment is when the note trades and it's no longer in institutional hands,
Right.
and everyone wants to know, like, how much do they pay for it? Can we find out? No, you can't find out.
And even if you do, it doesn't make a difference.
Right.
Right, they owe you par.
No, to your point, I'm in the middle of a few bankruptcies, let's say, right now. And one of the guys, we have a good case against the lender, and then, of course, the lender sells the loan, a new guy calls up, and he goes, I think he paid this. I said, and that doesn't help you. You can't be in the other guy's mind. What deal makes sense for you? If the deal doesn't make sense for you, he could have paid anything. And where people are mistaken, in my view, right now, is that they think that they have the upper hand against the lender. because I can put them into bankruptcy. There are some times that you can utilize tools in the bankruptcy to leverage yourself. And David will tell you that in a down market, most of those tools are gone, right? We're in a transactional bankruptcy market right now. You know, Greg and I just finished a sale a few weeks ago where the lender asked the borrower to go into bankruptcy because it's a very large loan amount, and there was some money paid by the borrower, but in order to get off the rest of their PGs, trading I think a $20 million deficiency for a $2 million contribution, and in the bankruptcy they didn't have to pay transfer tax for the sale. So there are a lot more transactional bankruptcies that are going on now, and the ones who are not set up like David is saying and not well thought through, like Greg was saying, most of the bankruptcies I filed up until 2 years ago were 5 seconds before the end of the game, just about before the sale. Still get some of those now.
You've done that to me too many times. Thanks a lot.
It's like, Greg, you have a UCC? Perfect. But people didn't want advice. Mikey made a very good point. If nobody's thinking, nothing is going to get done.
What do you mean transactional bankruptcies? What does that mean?
I want to get specific, right? Because we often talk about these things in an ephemeral sense as opposed to a static deal sense. A trip to Bowling Green can be one of two things: desperation or a plan. So if you've gone in with your lender, it's funny. Adam Altman, who was on the last panel, and I owned a building together in the Bronx years ago, with a very, very difficult borrower who had a hard time coming to Jesus, as the saying goes. And he threw a BK at the very last minute, didn't pay his lawyers, and was representing himself pro se in front of Judge Peck at the time. And it's literally like sometimes this business is more emotional than you might realize. It was sitting in the hallway with the borrower who had like lost his entire empire. And without transfer tax, there was no way we could give him a way out of the deal. And so he didn't pre-pack it, and it was a pretty disastrous outcome. In the end, we managed to buy a little time and work it out. But had that been a plan that was thoughtful, which we were trying to say to the borrower, look, doesn't matter what I paid for your loan, this is going to be a hard situation. You can put the bitter pill in applesauce, or you can force it down hard. And the impulse to fight, it's the same room, but when you're there with your lender, it's a very different situation. And you want to try and be as aligned with your lender as possible because you're both in a tough situation. So understanding that a bankruptcy is not a bankruptcy is a tool. And if you're swinging that hammer together with people who are sharing in a tough situation, you're going to have one outcome. If you're trying to say lender liability, I'm going to get them, I'm sure you get a lot of these phone calls of here's what my lender did wrong. And you're like, why don't you look at the dockets in the first department
But
and
first
see
he
how
says,
often.
wire me $100,000, then I'll look.
Exactly. But
That's the
pretty
friends and
important.
family rate. But to add to that, though, the main thing now is personal
Greg,
guarantee
I
and the
think you should
recourse.
address the transactional bankruptcy that he just asked about,
Yeah,
because we're in the middle of starting one right now. We've done probably 5 or 6 this
we're in
year.
the middle of
But
a
I'm saying,
lot, but yeah,
between you and David, to explain it so that people understand what that means.
Right, so we're horse trading a lot for the personal guarantee and the recourse. It used to be that these lenders would go through the foreclosure process to try to get the keys back to get the asset because there was equity. So they figured it was worth spending 2, 3, 4 years in New York, 5 years in New York to try to get to the asset. And now that they realize that the asset isn't even worth the debt, we try to add the value twofold. One is we're trying to get for our borrowers to get them off the PG and the recourse. And this can be not just from filing the bankruptcy, which is why I sometimes agree that, people to say, what, a bankruptcy is okay now. We've already triggered, the bad boy because they don't realize in their loan docs that it says if they take a couple of bucks from this account to pay, their other building that's struggling, they've now, violated some covenant or, commingled funds, and they don't realize that it's not a bad act on their part where they're doing something fraudulent or malicious, on purpose. They just wouldn't have thought of that, this building needs a little help. I took it out of this, and then I put the money back in the account. By doing that, they've already triggered those clauses. So the banks can say to them, the PG, the recourse, we're going after it anyway. At that point, the main thing of filing bankruptcy, the only thing left is the stigma of it. So if you can get past the stigma and you're already being held, for the PGs, there are a lot of advantages and very few disadvantages. As far as it goes, we're making deals with lenders right now where we say to them, look, you can do this, the hard way, which is spend years on the foreclosure, and then they're going to file a bankruptcy anyway, an hour before if you're dealing with David, a few weeks before if you're dealing with someone else. And
We've gotten down to 16 minutes on one of them.
and 4 minutes on UCCs. But back then it was, I'm sorry, we'd say that we would take that whole process, but we can say to them going in to the lender, why don't we file a consensual prepackage or a prepack bankruptcy? We're going to get this done in 90 to 120 days, and time is money. So you're going to let them off whatever, recourse or whatever you're going to try to go after them and sue them personally. But in exchange for their cooperation and getting this done, 4 months, it's over, no matter what the results are. Everyone agrees to the results versus your, chase for years and years. So in exchange for the time and the money, they'll do it with us, and we have a cooperative process. The last thing is typically when we get hired by a borrower, we are reporting to them. Any of the marketing materials will show to them the amount of inspections and the reporting and offers. Our discussions are with the borrower. If we, propose and get these consensual prepacks done, the lender likes to know that they're involved in the process. They want to know, how many websites it's up on and how many times we've been to the building and where all of the offers are going in. So they're getting that mark-to-market exercise and sort of price discovery along the way, which they are actually willing to pay for in the form of a carve-out. Even if we don't sell the building to a third party, this is valuable for them so they can go back to their, whether it's the bondholders or BPs or whoever the reporting committees are, and say, we ran a process. The reason we are giving this discount is because we know what the building is worth now after the process.
But I mean, it sounds like you're making deals with lenders who are willing to make a deal. What about the lenders that are willing to play dirty? They maybe want to take over the asset themselves or collect as much default interest as possible. What do you do there? What are your options as a
He calls
borrower?
me.
True.
How do you deal with that? I mean, what do you?
I think one of the interesting things that, we've toyed with is even though you don't have a right to give back the keys, is that better? Okay, even though you don't have a right to give back the keys, tendering the keys. And it hasn't been tested in court yet, whether if you tender the keys, that somehow mitigates some type of interest factor. But yes, you do have the situation where you don't have a right to give things back. The lender wants to see things through. But at the end of the day, there are really two things that the lender wants that it could get if it works with you. If they want the keys, they actually don't want you to give them back the keys. They actually want to take you through a consensual bankruptcy, or they want to take you through a consensual foreclosure, because that has the effect of cutting off secondary liens, mechanics liens, claims that other people in the equity may come and claim that they have rights to be in the cap stack. So being a cooperative borrower has a lot of advantages, because being an uncooperative borrower leads you to default interest and attorney's fees, which you're so underwater, it just makes a reorganization impossible. And that's why I think the borrower's tools, this notion of lender liability that's out there over the years, and I started doing this in the 1990s with the RTC days. This is my fourth cycle, and I've watched the loan documents have gotten better and better and better for the lender.
Yep.
Everything that we have done through the years to help borrowers have been turned around and have been mitigated against in your loan documents. So our tools are much more limited than they were a cycle ago, 2 cycles ago, 3 cycles ago, because every set of loan docs that comes around is being drafted in some way, shape, or form by litigators who are looking at what happened in the court and said, okay, that's no longer going to happen because you are waiving certain rights at the time you're initiating and taking your loan.
One of the things that you mentioned before about what do you do when you can't pay or the rate went up.
Right.
So, there are some parties in this room that were in the final stages of negotiating a deal with one of the larger lenders. It has been successful to come to the lenders with a workout proposal that includes money, that includes an execution plan, as I was saying before, and includes something that they can be that can be tangible to them, whether it's a pay down, as was mentioned, or it's putting up more money for construction that you used for interest reserve improperly, taking some of your construction money, applying it to interest reserve or interest payments. We've been successful in either cutting out or deferring interest in order to see the project through, and bringing in, I said, new money or new blood. I'm involved in a bunch of them like that. But, there are solutions when there's a normal lender with a solution-oriented head. Depends on whether it's institutional, whether it's, there are a lot of non-bank lenders who are very, very open to doing deals because they don't want their lines to be called, and there's other different, things that they want. CMBS lenders have, the special servicers have nothing but inducement to keep you in special servicing. So you can be talking to Ice and Winter. I mean, there are a few guys who are successful, but not, the success of a modification of a CMBS loan is different parameters than the success of a modification in a regular loan. And each type of lender, or like you said, if a predatory lender takes on a
Right.
deal with, and you wrote about one of mine extensively, in that case, we did have the judge with a finding that the lender improperly accelerated the loan.
Right.
And I could tell you that was one of a billion stories that people told me, but I saw the papers. They did, and the judge put it in the finding, and he took their legal fees from he took down the legal fees from a $9 million number down to $2 million, and stripped them of their legal fees because of that improper acceleration.
But that case can't become everyone's hope note,
Well, I'm saying
right?
that was the one time
Yep.
out of my entire career that it actually was true. Most of the time, it's just sour grapes. Well, the lender should have given me the money.
There are 6 cases where in New York history since the 1980s where there have been findings of lender liability, as people generally call to it, and every other one has failed. So
I have a good percentage.
It's every borrower's threat. The second they come to it, they say, I'm going to sue. They get on the phone with Rialto, and they're like, I'm going to sue you. And I'm going to clapping in the audience. And they threaten them, and they're like, I have a war chest that's bigger set aside for, fighting you than most people, their entire fund is.
And the quote unquote predatory lenders, they're just looking for an IRR, right? I mean, so is their IRR going to be 15%? Is it going to be 20 or 22%? And if you're dealing with some of those lenders that are looking for those types of returns, the longer you fight them, the more likely it is they may see that return. So those are the ones that people think they're looking for the fight. They are. They're looking for the fight. They're looking for the accrual of the interest. They're looking for you to trip recourse, and that's how they're going to make their money. They're the bullies. They're picking their fight. But at the end of the day, if you can find a way to recapitalize a deal, take them out, or make them part of the solution, bring them into a level on the equity and offer them something and be prepared to work for them. There are opportunities with everyone's in this for money. They're not in this to make people miserable for the sake of making them miserable, unless the misery is designed to squeeze money. So some of it is really your own pain threshold, and how much are you willing to take, and what price are you willing to pay for not having to suffer that pain.
But we see a lot of the misery that's, purposefully inflicted by lenders that are so fed up with the borrower. The worst thing is to like ghost one of the lenders. When the lender reaches out and they're calling you and they're emailing and there's absolutely no response from a borrower, that infuriates them and they take it very personally. They're just regular people. They get emotional and they're much more likely to go after you personally. And they'd rather take, $10 million from a regular guy than $11 million from you, because it's become this personal thing. So there is an element of, if you piss me off, then I'm going to, bring a little more fury to you than I would on if you're calling me back and you're working with me and you're involving me in the process.
And then that goes to the collaboration. I mean, collaboration is a buzzword in nearly every single industry. And if you can walk in earlier as opposed to later and dealing with your lenders, you're more likely as a borrower to try to find a solution than you are by picking up the phone and saying, you screwed me, I'm going to sue you, and I'm hiring David Scharf. So,
I think it's worth talking about what you own. I know, Greg, you've sold a bunch of these recently. If you own something that is capable of being an ATM machine, whether it works well or not, if cash comes out of it, you're having one lane of discussion. If you own a midstream development process where you're the GC or you control the GC, you control the permits, there's no C of O and there's no way to turn the money making machine on, you're having a very different discussion with your lenders because they can't complete. And so I think when we talk about this, people like to talk about things, again, broadly. Both David see this all the time, and Greg, you have to sell these all the time. When you've got, this one because it's been in the news so much, HAPS development in the 180s up on Fort Washington. It's a midstream development, as of right, 421A in place. Someone has to finish that. Someone controls the NB permits, which couldn't be built today under those old grandfathered permits. And so is that a very impaired situation? Yes. Is whoever going to buy that almost definitely going to complete it? Also, yes. What does the process of stepping into those shoes and completing look like? Well, for a lender, that's damn near impossible, right? You don't have the concrete testing cylinders for the TR2s and 3s from when that foundation got poured. You can't finish without them. You'll never get a C of O. And so depending on where you are in the stack, if you've got midstream development, everything we said goes out the window because it's a very different conversation than if you have something that's cash flowing. So depending on what you're investing in and where you've defaulted, I think everyone understands the Gordian knot of midstream development deals is a very different process. And you guys can speak to that better than I, but there's a lot of nuance there where the conversation changes.
That's a great insight, and I think everyone on the panel will say that the lenders always open up with, we are fine taking this asset back, we're happy to take it back, no problem, and you know that it's very infrequent that that's the case. The only time, and as you alluded to, if it's a cash machine or an ATM, and it's easy and it's stabilized and there isn't much work to be done to the units and it's already been renovated and you're just, clipping a coupon, the lender's more likely to almost want to take it back than something that we're selling a lot of stalled construction right now and a lot of, mid
A lot.
development. Yeah, a lot.
lot.
Mid.
I'm guessing it also really depends
And
on.
the banks they're not geared for that. They're a
Right.
lending, they're built around lending, not construction. So those things we know that if they're owed 20 million, they might be able to take, willing to take 13 or 14. Whereas if they're owed 20 million on a multifamily turnkey property, they're probably going to try to stick to the,
Right.
17, 18 range.
Right, right. I mean, it seems like it depends on the type of lender. I mean, some are developers and they're comfortable taking it over, but when we're talking about traditional banks, some of them are foreclosing on some pretty crappy assets, around New York. What happens next? What are they doing right now? Are they looking to sell these? How are they getting people to buy these assets?
Like, it's really hard is the short answer. A lot of these linger. Some of the really big headline ones that you guys have written about at length, obviously the Leaning Tower of South Street, there are ones where at any amount of dollars, you have real anxiety owning that because
I was, I put part of that to bank.
Well, that's all right.
those are really hard deals. And when the tickets get really big, you move beyond the realm of your typical syndicator, even one who's got a really great network of capital behind him. That becomes a stack of people. Like if you think about really big, leaving New York, if you think about the Fontainebleau, right? The Kochs bought that, right? The equity ticket there at whatever discount is so large that the number of people who can write the check greatly narrows the options for the lender. And so part of it is size becomes its own weird advantage. When the dollars get big, the realm of people who are going to Dr. Schwartz that deal to death, that doesn't work anymore.
Right. I mean, are the banks also having to offer deals on the back end? Like we've seen some of this where they're offering seller financing.
Yeah.
And SL Green has done this to get people, attract into deals because
But
otherwise.
I think it goes to his point that those are generally some type of a cash flowing deal where they know they're going to get an exit. Like you talk about the Leaning Tower, my personal opinion, and I ran the bankruptcy on the guy who was trying to buy the loan. My personal opinion is it's just land value. Like if you really look at what it takes to get that building finished, I think it needs to be demolished and its land value, which is not much. Because they're owed, there's 200 and something million dollars owed on the building, and it's gonna cost $80 million there's just almost no answer.
Why don't you give everyone some brief background on the Leaning Tower? For those of you who don't know, it's right on the water in the financial district, and it has been known as the Leaning Tower because it's allegedly leaning 3 inches, I think, to the north. There's multiple foreclosures going on. It's like a skeleton. Anyone who sees it knows this building, and it's just a disaster.
Right, I'm saying that's the one where you call 911 and they say, you
Right.
might as well jump. We're not helping you.
Right.
Well, you want to put a fork in that, right? It's a UCC problem, right? So you talk about, to David's point about a 363 process. If you've never been to a closing in a bankruptcy, you'll get the messiest title in the world, and as a real estate guy, your blood starts pumping because the trustee has a stamp that says omit, and they just omit everything, and everybody's blown out, and the unsecureds are gone, and it's clean title. But if you can move against a property like that through a UCC, you're stepping into the shoes of the borrower mechanically. And so every claim that existed against the guy who had his stress now exists against you. And so are you willing to step into an unknown Gordian knot of challenges? And that the only way that clears is through a bankruptcy proceeding, because no one's going to take it to any amount or subject to any amount of uncertainty, because what that uncertainty is an unknowable unknown. And you're not going to extend the balance sheet against a challenge like that. Just rational people won't do that with fresh capital. And so the only way to flush those out is through some mechanism that blows out the unsecured and the downstream, because otherwise you can't own it.
There's an interesting phenomenon that I think we're seeing in addition to everything that's being discussed, and that is DPO, discounted payoff, seems to be a dirty word. You can't ask for a discounted payoff, but you can ask to try to buy your loan and take an assignment of your loan and get somebody to pay it. Now, there's also this notion out there that lenders won't sell their note to their borrower. Now, sometimes that comes up because if there are multiple pieces of debt in the stack under the intercreditor agreement, that's something that's forbidden. The opportunity has to be in the existing debt stack, and it can't be given to the borrower. We've seen that come up in the UCC foreclosure world, where borrowers can never become an accredited bidder to bid, which has, fostered and fomented plenty of litigation that many of us on the stage have been involved in. But if part of your conversation is come to your lender and they have the ability to deal with you, asking them for a discounted payoff, they're usually going to throw up on it. But talk to them differently about it, and sometimes it's just the use of language, and say, listen, I'm recapitalizing this deal. I'm going to do a recap with you, and as a part of the recap, I'm bringing in new equity. There's somebody else who's going to be coming in, maybe stepping in as a guarantor. But for that, we're going to want the note to be sold. And they'll sell it at a discount, even to an affiliated entity if they can, under the loan docs, under their intercreditor, but won't give you a discounted payoff. I don't know what's behind the curtain as to why that is, but it's just been an interesting phenomenon that I found with many of the bridge lenders who are out there. It's like, oh, we won't, no discounted payoff, but bring somebody else in to will want to buy their note. Somebody's going to be giving you new capital, and they're like, oh, sure, okay, 10%,
I think
that's
it's
fine.
optics though too, because they're rewarding bad behavior. If they sell it to a third party, even if it would be for less money than that borrower is willing to do, even if it's not in the documents that they literally cannot sell it legally to the borrower, they're setting a precedence where someone says to them, I know I owe you 20 million, will you take 15? They say, great, let's settle on 17. That DPO becomes, especially in this insular community, everyone starts talking. The next thing you know, every phone call to that bank is, hey, I heard you did it for Chaim or Shlomo. Why don't you do it for me?
Yeah.
So then that 20 to 17, they say, well, I'm even better negotiator. Will you take 15? So once they start working with the borrower and giving that borrower just a lower number or a discounted payoff, the precedence is set and then the floodgates open. So that's why they can justify selling it to a third party a lot better than working with the current borrower.
Also, your marks become really, really important. So everybody's trying to hold marks wherever they can, because your regulator, if you're not private credit, if you're a bank entity, your regulators are pretty sensitive to where you're marking these positions. And so X LLC, care of David, right? No one knows who's behind that. It's pretty opaque. And to other David's point earlier in the conversation, well, where did that trade? What was the discount? First, you're not going to know. Second of all, no one's going to know who owns it. So if you take a discounted payoff, that is disclosable and it is discoverable if someone knows how to look. And so the advantage of moving the note is you have no one knows, I mean, the rumors in the market being what they are, no one knows who bought it and no one knows what they paid. And so from a marking perspective, creating bad precedent in the market about where your positions are going to mark and everyone coming at you and thinking your pants are down, that's not a place any regulated lender wants to be. That's a bad place to be. And so if they can move it without taking discounted payoff, you'd rather sell the note and that goes into a slush fund of generic losses for the quarter. So if you want to take your marks, that's a much cleaner way of doing it with a lot more artificially engineered opacity.
It's a lot of words.
Sorry.
That's really
And
interesting.
polysyllabic words while he was at
Well,
Polysyllabic word.
and another point on that, Michael, that we were talking about this earlier is, and David, you brought up this point about the leaning tower. You think it's valued at land. How are you valuing anything right now? I mean, things are all over the place. Trades aren't even really. There's not that many deals happening.
We
right
asked
now
Greg, he
on
tells
big
us what the
ticket.
value is.
Yeah,
Craig, what's the clearing
yeah.
price?
How do you? So how do you think about valuations right now? How do you value things at this point?
Look, so that is the area where we spend a lot of time. It's really hard to buy things now. And every investor conversation you have with people who have capital that's waiting is, have we bottomed out? Where's the falling knife? Am I too early? Am I too late?
Right.
You look at big trades and you wonder, like, what the motivation behind a $10 billion apartment REIT is. It's someone in an institutional capacity trying to say, we've hit bottom. I just put $10 billion out to pasture. I can prove we hit bottom.
And they did this well in the office market the
Oh,
last.
they sure did, right? So you try to think of, like, what are the external motivators to a trade? How much of that is remarking a position when two partners in a deal sell another piece of a deal to each other at a valuation that's really high? Any third party appraiser is going to be able to justify that mark. And so if you're bringing fresh dollars, it's what do you need to earn and how much risk are you taking? And I think that's a pretty fluid conversation for everyone in the room who's got capital. I think people are still really struggling. Like, my favorite thing to say, in the last panel, someone talked for a moment about how it's 50% operations. With all due respect, I think that's total bullshit. I just don't think it's true. If you're a really good operator, if you can turn $100,000 of NOI at some multifam property into 150, you're objectively good at your job as an operator. And it doesn't matter because $100,000 of NOI at a 4 cap is worth $2.5 million and 150 at a 6 cap is worth $2.5 million. We're all far more exposed to Mr. Muss's point earlier to how interest rates are really driving tail value. And so we think we can operate our way out of challenges, but the truth is you're dividing by a fraction and cap rates work in a way that's pretty ugly when rates go up. And so you can't grow your way out of this problem. That's just not true. And I think most people who are good operators, and everyone in the room is probably a really good operator, want to believe they can work their way through this challenge, but you're swimming in quicksand. You can't. Rates have made that impossible
Insurance.
yeah, it's hard.
But what you mentioned about, what are property values, and that's obviously the zillion-dollar question. People are not referring to comps like they used to because what happened 6 months, 12 months ago in a rearview mirror, completely irrelevant. They're also not replying on appraisers because if you ever go to these panels and they poll the audience or they ask the panel, what's an appraisal worth? Is it worth a month or 6 months or a year or nothing? Is it toilet paper? And
Depends if you
you'll-
ask Judge Angora and the Trump case. So,
right. So people are not relying on comps. They're not relying on appraisals. What they are relying on is these mark-to-market exercises that we're running. And typically, if a lender is not sophisticated, they would say, why would I pay you, Greg, or someone like you to take my own property back? It doesn't make sense. But what I had alluded to before is that sophisticated lenders realize that there's a huge value to knowing what the market is today for that asset on that block in that portion of stalled construction, whether it's 20%, 60% wood frame. There's a lot of nuances to it. It's very asset specific.
But here's the thing, Greg and I have worked on a project together, and the beauty of the transparency of the bankruptcy, different than a UCC sale, different than is that there's a finite selling period of time. You have somebody like Greg who's out there who's marketing the heck out of it. And he's not just marketing it to his mailing list, he's out there because he knows who the potential buyers are and he's talking to them. And if you end up with a bankruptcy process that has a stalking horse, you know that you're going to hit a certain price. And that's all negotiated out with your lender, with everyone who needs to get paid out of a bankruptcy plan. And all of those factors are taken into account, and it's approved by a judge who's saying everything was done to its absolute pinnacle to achieve the best and highest and best price. And that's one of the advantages of why, when we go back to the beginning of our conversation, at the beginning, what are the advantages potentially of a bankruptcy, is pricing transparency. If as Greg was alluding to, if you have a borrower who's picking the broker and is running the marketing process and is simply reporting to the lender, and they don't trust each other, that breach of trust or that lack of trust is going to create a disconnect on what the lender may be thinking about is going on behind the scenes.
Right.
Who else is getting paid? How was the broker selected? What are the kickbacks that are going to be going on? How is all this going to operate? In the bankruptcy process, it's all clean, it's all transparent. Everyone who's getting paid is getting paid pursuant to a retention arrangement, and the pricing transparency is there because on this block, this piece of property in this state, with no reps or warranties, come in and do everything, and it's got to close within 90 days. And somebody already thinks it's worth $22 million. So do you want to top it or not? And that's what the lenders are liking. And frankly, borrowers who can get past. And it's not something to be taken lightly, because I think everyone in this room knows when they fill out a loan application, they've got to say whether or not they have ever filed a bankruptcy. And I get all the calls. Does it mean me personally? Does it mean an entity that I was affiliated with? What happens if I owned a third of it? All those questions are legitimate and appropriate questions to be asked. But there are legitimate reasons for people to be filing bankruptcy, to create pricing transparency and room in the capital stack by virtue of saving on transfer taxes and the cancellation of indebtedness.
But it
There's
also.
no one better than this gentleman in the United States of America to answer those liability questions of filing those bankruptcies.
Thank you, Greg. Good plug. But, one of the other questions, as David, you're talking about, is how many other properties do you have? How many loans do you have? If a certain person would be signing on the petition, will that trigger other loan defaults in your portfolio? So these questions are much higher stakes than one deal.
Right. David is the master of governance pre-bankruptcy issues. So.
I want to move to offense for a second, because this becomes pretty instructive. I'm sure everyone in this room who gets broker listings understands your pulse quickens around certain deals more than others. So if there's a sense that someone bought this cheaply and they're going to credit bid, as a potential buyer, you're not going to want to spend a lot of diligence dollars chasing down a pretty complicated deal to figure out if you want to buy it, if you think it's going to be a no trade or it's going to be a credit bid from somebody. One of the beauties, and this is why it's actually very much worth hiring the folks on this thing, not hypothetically, but if you want it to trade for a higher price, you want as many people as possible. As a borrower, you want as many people as possible to meaningfully kick tires. Because if everybody feels that it's an inevitability and this is going to go to the lender, no one's going to work the transaction hard. And the harder the transaction is, the more work that is, the more diligence dollars there are. The beauty of a bankruptcy is, first, the best business in the world is being a stalking horse, because you're picking a number where you want to own it. And if you don't own it, you're going to get a breakup fee or overbid protection. These guys can talk about what that means. You're either going to get a breakup fee for 90 days work and not end up owning it, or you're going to own it at a level you really, really like. And how often do you not have a stalking horse? It's pretty often. That's a great thing to offer any of the folks on the stage, saying, I like this thing. I know it's worth more than this, but here's my stalking horse bid, and I'm going to close. It is literally the easiest money to make in the entire world, or you're going to own this at a level you want to own it. So that's just a great way to think. But it's also, those are good deals to work on because they're going to trade. It's going to trade. There's not going to be 50 people kicking tires. There's a lot less competition because it's expensive and it's complicated. So engaging a little bit in expense and complication, the likelihood of you winning the bid and winning it with clean title in a bankruptcy is probably the highest of any kind of transaction you can engage in as a potential buyer.
But it also brings, and Greg will talk to, we did one auction where we got a stalking horse, and the stalking, or it just brought the numbers up so high. It's time and time again that numbers we never thought we were going to achieve, and people get very crazy at an auction. And because once they get emotionally involved and think they're going to buy the property, they go wild.
Right, what's another $500,000 if you're in already for 19, right?
Right.
And Meredith, if you're the
Right.
borrower here, the value of that frenzy to you is reducing your deficiency dollar for dollar. So your thought of, do I want to give up early? It's actually, you want to engage a really strong team as fast as possible. If you can get your lender on board and pre-pack a bankruptcy and run a lengthy, well-organized, cooperative process where you're letting people see the documents, especially if it's construction. If you're blown out, you're now playing defense personally. The better that process becomes, the higher the likelihood of two people really both loving it and getting a little bit aggressive. We've all seen what happens at an auction on the courthouse steps. Emotion tends to take over because there's so much sunken time and cost. So if you're the borrower, you're smiling because yes, it's a bad day for you, but every incremental dollar that property trades for is really good news for a borrower facing a deficiency.
A stalking horse is very, very important for us for a number of reasons. First off, it sends a message to the market that the lender has resolved to let the property go. So one of the first questions people always ask when we come to market with a new listing is, does the lender want this? Are they going to credit bid? You know, am I wasting my time? Is this just a wheel spin? Why am I putting time and money into something that, you know, the debt is 20 and the property's worth 10? The lender's going to credit bid because they don't want to, you know, take that loss officially on their books. So once we get that out of the way, whether we speculate or whether we may or may not have a lender that wants to credit bid, if that lender agreed to allow a stalking horse and allow a breakup fee, that sends the message to the market that the lender does not want it back, because in and of itself, to allow that person to get that breakup fee, that would be money that's going in the lender's pocket, which, you know, would thus not be there. So it's very, you know, makes our job a lot easier when we are allowed to put a stalking horse in place.
And that's where the lender will want to put skin in the game as opposed to just giving their borrower a discounted payoff. And it's a psychological thing, but that's the opportunity where also for the borrower to really maximize its value or minimize its loss.
Okay, guys, that was a good conversation. I think our time is up now here. Unless anyone has any questions from the audience, I do want to, if anyone has like one question, I'll open it up. Otherwise, thanks for being on the panel. This is awesome.
Thank you. Thanks.
Yeah.